Good evening. I am Sheila Boston, the 69th president of the New York City Bar Association, and I want to welcome you virtually to our Leslie H. Arps Memorial Lecture. Please know, I'm so sorry I could not be there in person, but rest assured, with the House of the Association now fully reopened, I, your virtual pandemic president, will be attending as many events as possible over the next few weeks as my presidency comes to an end. Now, I hope that everyone under the sound of my voice is healthy and well in mind, body, and spirit. I say this reminding everyone that mental health and wellness is one of the pillars of my presidency at our beloved Bar of Hope. So please be kind to yourself and take very good care of your health in a holistic manner. For those of you who may not know, the City Bar has been hosting the Arps Lecture, with the exception of the past 2 years, since Supreme Court Justice Lewis Powell gave the inaugural lecture in 1989 on the subject of stare decisis and judicial restraint. Tonight's speaker is the Honorable John Gleason. We are indeed fortunate to have John Gleason speak to us tonight as the most recent legal luminary to continue this historically important tradition. You'll hear a full introduction of Judge Gleason by Scott Musoff in a minute. But on a personal note, I would just like to say that I have immense respect and admiration for Judge Gleason. And suffice it to say that it is our collective great privilege to hear the judge's insights. And we are so grateful that he is taking the time to speak with us this evening. The Arps lectures are made possible by the generosity of Skadden Arps, Slate, Meagher, and Flom. In addition to his prominence at Skadden and in the legal community, Leslie Arps served as chair of this association's executive committee in 1973 and 1974. I wish to extend my heartfelt thanks to Scott Musoff, a partner at Skadden Arps and chair of the committee overseeing the Arps lecture. Thank you so much, Scott, for bringing us back here after a 2-year hiatus. I would now like to ask all of you to help me in taking a moment to honor Barry Garfinkel. He passed away last year in August 2021. A longtime partner at Skadden Arps, Barry Garfinkel was the guiding hand behind the Arps lecture for all these years. I didn't have the privilege of knowing Barry personally, but I have heard from others that he was a great lawyer and, equally as important, a great mentor to younger lawyers. Skadden's tribute to Barry certainly reflects how beloved he was by his colleagues. I also know from my City Bar colleagues that Barry was deeply devoted to the Arps lecture as a way to educate our members and the public about critical and timely topics. We are so appreciative of the legacy Barry created and what he and Skadden have done to establish this event and maintain it as one of the highlights of the year at the association. So, to honor him, let's just pause now for a moment of silence. Thank you all, and blessings upon Barry Garfinkel's legacy. Now, I am pleased to turn things over to Scott Musoff so that he can introduce our special guest lecturer, Judge Gleason, and the topic of this lecture, criminal sentencing. This is a topic near and dear to my heart as it intersects with 2 of the 6 pillars of my presidency, criminal justice reform and diversity, equity, and inclusion. I and so many of my City Bar colleagues believe we can and we must make our criminal justice system, from the first police interaction up to and including sentencing, fairer and more equitable in this country to create a more perfect union. I'm so very grateful that Judge Gleason has chosen this important issue as the topic of his lecture because, as with all things, the better we understand something, the better equipped we are to change it. Thank you all so very much for attending. Thank you for your City Bar membership, and please, everyone, enjoy the lecture. Scott, I'm now passing the mic over to you.
Thank you, Sheila. And thank you, everybody, for being here. I'm just going to spend a moment or two to just talk about Les Arps and mix it in with a little bit of Barry Garfinkel and then introduce Judge Gleeson. I am particularly pleased and honored to have Judge Gleeson be the 17th Arps lecturer. And when Barry informed me of that selection, it meant a lot to me because my professional career, as I'll touch upon in a moment, began with an internship with then John Gleeson at the U.S. Attorney's Office in the Eastern District. But let me just start for just a minute about Les Arps. Early in his career, Les Arps was an assistant to John M. Harlan prior to Harlan's appointment as an Associate Justice of the U.S. Supreme Court. In 1942, Harlan recruited Les Arps to serve in England as his assistant in the Army Air Force Operations Analysis Section, where they analyzed the accuracy of bombing and air gunnery in the war. A few years later, on April Fool's Day in 1948, no joke, Les Arps, along with Marshall Skadden and John Slate, formed Skadden, Arps, and Slate, which began as a scrappy upstart firm among a sea of established white shoe law firms in New York. Les continued his public service even after forming the firm, serving on the waterfront and moorland commissions, among others. And then it was only a few years later when Les Arps and Joe Flom recruited Barry Garfinkel to join Skadden in 1956 as its 9th attorney. And Barry, as many of you know, became one of New York's most accomplished litigators. He led Skadden's litigation group for many of its formative years and then oversaw the development of its international arbitration group. But as Sheila mentioned, what Barry was most known for was his mentorship, his training, and his leading by example. And he helped countless young associates, including myself, develop into well-rounded and respected litigators and international arbitration practitioners. And up until his death, Barry continued to work and meet with first-year associates, always urging them to join the city bar. I think if you go back, I probably joined the city bar my first few weeks at Skadden because Barry came into each one's office, urged them to join the city bar, get involved in committees, and show how important it was to the legal profession. My last conversation with Barry was literally a few days before he died. And in his trademark baritone voice, he told me there wasn't anything left for the doctors to do, but then quickly transitioned to the Les Arps lecture. And he boomed through the phone, "Scott, I had Aphrodite, his longtime assistant, send you my files on the Arps lecture. Don't let John Gleeson down and make sure it goes off without a hitch." And Barry, I'm going to try and do my best to make sure that happened. In fact, John Gleeson was asked to give this lecture in 2019 to have it presented in 2000. But with the onset of COVID, Barry was a big proponent of waiting till we could do it in person. And I'm so glad we did. I think we've learned that we probably shouldn't pick Mondays necessarily as our in-person event days, but it's still great to see this group here tonight and many others that are going to be watching on video. So Judge Gleeson joins an auspicious group of Arps lecturers. As Sheila noted, Barry started the Les Arps lectures in 1989 with Supreme Court Justice Lewis Powell giving the inaugural lecture. We've had Sandra Day O'Connor speak, and so many other luminaries of the bar and the judiciary. And I'm proud to introduce the Honorable John Gleeson as he's added to that esteemed list. Judge Gleeson is currently a trial and appellate lawyer in Debevoise's White Collar and Regulatory Defense and Commercial Litigation Groups. A fellow of the American College of Trial Lawyers, Judge Gleeson's practice focuses on white-collar defense, complex civil litigation, internal investigations, and dispute resolution. Since joining Debevoise, in addition to his numerous matters in federal, state, and arbitrations, he has also been appointed by 3 federal judges to argue important issues of federal criminal law and procedure, including having made the argument against the government's motion to dismiss the prosecution of former National Security Advisor Michael Flynn, which John did unsparingly. Judge Gleeson is ranked as a leading lawyer in chambers, where clients describe him as a thought leader and a skillful trial lawyer with great judgment. Prior to joining Debevoise, as most of you know, Judge Gleeson was a United States District Court judge in the Eastern District of New York. He authored more than 1,500 published opinions and presided over more than 200 civil and criminal jury trials. And before his appointment to the bench in 1994, Judge Gleeson was a federal prosecutor in the Eastern District. He served as Chief of Appeals, Chief of Special Prosecutions, Chief of Organized Crime, and Chief of the Criminal Division. He personally tried 20 cases to verdict, argued over 25 appeals to the Second Circuit, and among his numerous high-profile cases he tried, Judge Gleeson was the lead prosecutor in the murder and racketeering convictions of John Gotti and Victor Arena, the bosses of the Gambino and Colombo crime families of La Cosa Nostra. And it was in that setting where I first met Judge Gleeson. I was an intern in the summer of 1992 in the Eastern District U.S. Attorney's Office and assigned to the Organized Crime Group. And that June, after John Gotti was convicted in April, I got to sit in the well of Judge Glasser's courtroom for the John Gotti sentencing. By that time, Judge Gleeson had already earned the nickname Clark Kent because he was not only straight as an arrow, but he was like Superman of sorts, as he was the lead trial lawyer and finally convicting what was nicknamed the Teflon Don at the time. And I remember walking into the courtroom, crowded, not a seat in the courtroom. That's how I got to sit in the well. John turned to me and said, "Just follow me," and then pointed where to sit, as John Gotti's friends and family were mumbling many other names other than Clark Kent under their breath as you walked down the aisle. And what I remember was Judge Glasser giving multiple life sentences, and at each one giving a $250 special assessment, which was quite ironic for a life sentence. But I think what's most important, as the New York Times reported, after Judge Gleeson got on the bench, his vision of criminal justice system and his sense of empathy seemed to broaden. John Gleeson was an early advocate of the federal sentencing overhauls and was a driving force behind bringing special drug courts to Brooklyn, working with pretrial services to start a program that allowed drug-addicted defendants to avoid prison time by achieving sobriety. In more than 2 decades as a judge, he regularly visited prisons to ask inmates about the experience of being in custody. I can't think of anyone with more credibility and qualifications than Judge Gleeson to give today's Les Arps lecture on racial disparities and second looks in federal sentencing, a window into dysfunction and a path out of it. And I'm now honored and privileged to bring you our 17th Les Arps lecturer, the Honorable John Gleeson.
Thank you, Scott. That was a very kind introduction. Thanks to the City Bar for according me this honor of giving the Les Arps lecture. I'm flattered and hope not to disappoint. I'm really grateful to for the recognition of Barry Garfinkel. We were by no means contemporaries, but I've known him my whole career. When I was a young lawyer at Cravath, I was teamed up on a case against him. And even for young associates who are on the opposite side of the case, he provided mentorship, and I stayed in touch with him until his death. So I'm grateful for the recognition of him. I'm going to talk, as you can see, about racial disparities in federal criminal justice, and one in particular. I'm going to talk also about second looks at lengthy federal sentences, which for all practical purposes were wiped out when we entered the new determinate sentence regime in the mid-'80s, and how that's changed in the past 3 years, how there is a second look now, hopefully for good. And I'm going to talk about dysfunction, and specifically our inability even to discuss, let alone do something about, undisputed racially discriminatory invocations of mandatory sentencing provisions in our system. It's a very uncomfortable reality, and we're not good at dealing with it. We need to get better at it. My remarks begin with the Holloway Project at Debevoise. I left the bench in the spring of 2016. That summer brought a couple of tragic installments, or chapters rather, in the book that later included George Floyd. And that summer it was 2, on successive days, killings of black men by police, one in Louisiana, the other in Minnesota, which led to an all-hands meeting at our firm, meaning not just lawyers but staff, many of whom relayed truly troubling stories about their treatment by police as they were walking out of the hallowed offices of Debevoise and Plimpton. And it was, I was new to the firm, but it was a significant moment for the firm. The firm asked me, understanding I was engaged in sentencing reform before I left the bench, whether there was something concrete the firm could do about racial inequities in federal criminal justice, something specific. And I said, there sure is. It's the Holloway Project. And the origin of that response, that immediate response, was this case, U.S. versus Holloway. I was a brand new judge on the bench less than a year. Francois Holloway came into my courtroom charged with having participated in 3 carjackings, robberies of cars. And, you know, our system accords a great deal of discretion to prosecutors, and in a case like Francois Holloway's, which involved, he had a chop shop, he chopped up cars for a living, he needed cars for the raw material for his business, and he and an accomplice who had a firearm stole 3 cars at gunpoint in a span of 24 hours. No one was hurt, but obviously it's a very serious crime. But the discretion accorded prosecutors includes, in a case like that, the ability to just charge the robbery for each car that Francois Holloway stole, and to seek an upward adjustment at sentencing for the presence of a firearm. The result would be an upward increment of maybe 3 or 4 years in sentence, or a much harsher choice, which is to invoke this 18 U.S.C. Section 924C, which prohibits the use of a firearm in connection with a violent crime, such as a robbery, which carried at the time the most severe mandatory sentences in the federal system, which is saying something, because there's a lot of severe mandatory sentences in the federal system. And specifically at the time Francois Holloway came before me, the first 924C was a mandatory consecutive 5 years. Second or successive 924C convictions were mandatory consecutive 20 years. Later upped in 1998 to 7, 25, and 25. So the other option accorded prosecutors, in addition to deciding whether to charge a 924C count, is whether to agree to dismiss it in exchange for a plea of guilty, which became common. So in Holloway's case, he had a plea offer. If he would just plead guilty, he would face just the single 5-year mandatory 924C count and serve a sentence of approximately 9 years. But he exercised his right under our Sixth Amendment to trial by jury. When he was convicted of the 3 carjackings and the 3 924C counts, I had to sentence him to 57 years in prison, 45 for the 924C, and under the then mandatory guidelines, 12 years. That sentence literally kept me awake at night for years because of the obvious. Francois Holloway paid for the right to trial by jury with almost 50 years, half a century of prison time. And my anxiety over that sentence only grew worse when the Sentencing Commission began to publish data about the racially discriminatory invocation of that harsh route of the 924C route, beginning in 2004 and 3 times, 2004, 2011, 2018. Obviously, the 2018 version was after the events I'm going to finish telling you about in a minute regarding Holloway's case. But on 3 occasions, the Sentencing Commission, not known for ringing alarm bells in ways that inure to the benefit of defendants, 3 times the Sentencing Commission reported that the discretion to invoke this ultra-harsh penalty was exercised in a way that was racially discriminatory vis-a-vis black men. It was quickly, because I want to allow time for questions and answers. Those eligible were, as you can see here, in 2004, 48%. Those charged, 56%. Those convicted of stacked multiple 924s, 64%. And then in 2011, these notable demographic differences. Am I on the right slide here? No. These notable demographic differences continue. Black defendants were the majority of individuals convicted under 924C, 61%, significantly higher than the eligible defendants in the federal caseload, received stacked 924C sentences. The commission said to Congress then, do something about it. Make them permissibly concurrent. Eliminate the stack requirement and make them truly a recidivist statute, which they were not, because the second or successive conviction with the mandatory consecutive 25 years could be obtained in the same case as the first. And then again in 2018, the commission once again, this is 9 months before the First Step Act, which I'll get to in a minute. Now, by that point, 70%, fully 70% of those serving stacked 924Cs were black men. A real problem. The punchline here, this was an undisputed, has never been disputed, and I'm going to talk to you about a course of litigation in which DOJ might have if it were disputable. Discriminatory exercise of discretion that afflicted our system. It's a given. Now, back to Holloway. He, long after his direct appeals, his case actually went to the Supreme Court on one issue, but long after his direct appeals and collateral attacks were exhausted, he, like most folks who are going to spend most of the rest of their lives in prison, don't stop writing their sentencing judges. He wrote to me in 2014 there was no basis for relief. There was no defect in his conviction or sentence. But he was now almost 2 decades into a sentence that, as I mentioned, kept me awake at night. So I issued an order. I called it an order. It was really a request of then U.S. Attorney Loretta Lynch, setting forth this sordid racial disparity in the deployment of 924C, setting forth my views about the excessively harsh nature of those punishments, and asking for mercy. Asked her to agree to vacate 2 924C counts. And to my surprise, she agreed. She had an assistant U.S. attorney come into my courtroom and agree to dismiss 2 of Francois Holloway's 3 924C counts. I had been in the habit of writing opinions criticizing the exercise of discretion by that office, especially as it related to drug offense mandatory minimums and in other contexts. So I thought it only fair to write an opinion applauding U.S. Attorney Lynch's exercise of discretion, and that opinion set forth the racial inequity, the excessive harshness, my views about how the principle of finality in the system did not prohibit U.S. attorneys from agreeing to relief. And punchline was Loretta Lynch allowed me to give Francois Holloway back the rest of his life. And I did, and you can see here this photo from the front page of the New York Times of his family after his release. By the way, he's doing great. I speak to him regularly. He got a job. He lives in the Bronx, got his own place, takes care of his family. He's out for 8 years. He grew up in prison, as many men in his situation do, and he's doing great. The news of that opinion spread like wildfire in the Bureau of Prisons. I got hundreds of letters from men serving stacked 924C sentences, and they were mostly just thank yous. They're not a segment of the prison population that is considered very warm and fuzzy. There's nobody out there looking after them. And I got one card from a group of inmates in USP Pollock, Louisiana, that just said thank you for caring about us and then there were 16 of them, and they signed it, and they put the number of years they got. You're on that letter, Kevin. 46 years underneath your name. I noticed that for the first time today. I'll introduce you to Kevin Haynes in a few minutes. So, look, I knew immediately what I was going to do in response to the firm's request. I had those letters. I had a client base already. We decided we were going to try to rectify the unjust sentences of all those men, and there are more than 2,500 of them, doing stacked 924C sentences. Quickly, to contextualize, where the Holloway Project fit in the landscape of sentencing reform. And just to give you why sentencing reform was needed, this is a graph of the federal prison population. The determinate regime came in the end of the 1980s, and you can see what happened. The prison population graph almost became strictly vertical. We got to a point roughly 10 years ago where people on both sides of the aisle started to think, well, maybe we've overdone it a little bit. We got an over-incarceration problem. And that's when sentencing reform notions began to get traction. Again, to contextualize where the Holloway Project fits, nonviolent drug offender sentences from the onset of this new regime were absurdly lengthy because of mandatory minimums, recidivism-based enhancements, the linkage of the guidelines to those mandatory minimum drug types and quantities. So there was a good deal of reform in that regard. There were reductions, retroactive reductions of drug sentences in 2007, 2010, 2014. There were alternatives to incarceration. Thank you for mentioning the drug court in Brooklyn, Scott. I'm very proud of that. We went from a regime in which, back in the late 80s, fully half of the sentences did not involve incarceration, to a regime in which only 7% did not involve incarceration. We went overboard in that regard, too. So alternatives to incarceration began to take hold. And then on the reentry side, there were any number of initiatives to help people reenter. But against that backdrop, think about guys like Francois Holloway, defendants convicted. They got thrown under the bus, right? The implicit in let's help get sentencing relief for nonviolent drug offenders is like, let's not get relief for other folks, right? Defendants convicted of violent crimes, even worse, multiple violent crimes committed with firearms. And let's be clear, even if no one's hurt, even if very little is taken, these are classified as violent crimes. And they're serious crimes, there's no doubt about it. But these are I'm fond of the phrase, the highest hanging fruit of sentencing reform, because those are our guys, right? They were clemency proof. Barack Obama granted 1,715 clemencies. He should have granted more, but that's a lot. Not a single stacked 924C person in there. There were no law school clinics for such defendants. They had nobody but us. They were going to be all our own. So that's what Holloway set out to do, was to rectify indisputable racial inequities in a class of defendants who were serving bone-crushing prison terms. So we set out to do that, and the first phase of the Holloway Project we call the Supplicant Phase, because I decided we were going to go out and have U.S. attorneys, we're going to ask them to do what Loretta did. And hat in hand, supplicants, ask for mercy. And it was an abject failure. 2.5 years asking we would write letters to the U.S. attorneys, CC them to the judges, ask the U.S. attorneys to have a heart. On half a dozen occasions, the judges wrote to the U.S. attorneys and say, do what Gleason asked you to do. They'd been lying awake at night on those sentences, just as I had been in Holloway. But to a person, they said no. Many have criticized me for being naive during that phase, but come on, I was in the, before I left the bench, I was 1 for 1. I only asked one U.S. attorney, and I got it. And then I went 0 for about 30. And it's been pointed out to me that, when I went 1 for 1, I was an Article 3 judge. And then I, rejoined the unwashed. So that's when I went 0 for 30. But then, proving that it's better to be lucky than smart, me, that is, I got lucky. We got lucky at Debevoise. I'll go to my grave grateful to Debevoise for sticking by me through 2.5 years of abject failure. And the First Step Act comes along in December of 2018. And it had 2 fundamentally important provisions to it. One was Section 403, which had good news and bad news. The good news is you could no longer stack 924Cs in the defendant's first case. It turned these bone-crushing, mandatory, consecutive 25-year sentences into true recidivism sentences. So you could not get them in the first case, the case in which the first 924C conviction was obtained, which was all of our guys. So that was good. The bad part is, unlike some other sentencing reforms in the same law, it was not made retroactive to folks who had already been sentenced. So there was that. But then there was another piece of the First Step Act which was critical, and it amended what we came to know colloquially as the Compassionate Release Statute, the Sentence Reduction Statute, which permits sentence reductions for age, severe medical condition, extreme family circumstances, so very extreme family circumstances. And then there's a less specific ground, which is extraordinary and compelling reasons. And truth be told, we all think that second looks disappeared, because it seemed that way, when we got the new regime, when parole was abolished. But truth be told, Congress actually intended the Compassionate Release Statute to be a safety valve, for lack of a better way of putting it, for the abolition of parole. It intended to replace opaque parole commission review of every sentence with transparent district judge review of a narrow slice of sentences, those fitting those categories I described for you. But it made a mistake because it installed the BOP as the gatekeeper. And for decades, BOP hardly ever opened the gate, and it only did it in very rare instances. When it did it when someone was on death's door. So we all came to associate compassionate release with BOP never granting it, and when they did, it was in very narrow circumstances. Congress took BOP out of the middle in the First Step Act and allowed inmates to make sentence reduction motions directly to the court in which they were sentenced, if the judge were still around, directly to the sentencing judge. And one of the grounds was extraordinary and compelling reasons. So before I talk about our project and how it availed itself of that opportunity, let me tell you, just so you know, because this is like ongoing stuff, and it's interesting, threshold legal problems. One was the Sentencing Commission hasn't had a quorum for 3 years. And the law, the sentence reduction law, requires judges to follow applicable policy statements of the Commission. And the Commission's policy statement says that a sentence reduction for other extraordinary and compelling reasons can only happen when they're determined by the director of the BOP. P.S. on that one, 10 out of 11 circuits have said, no, that's not a problem for people making motions. That limitation applies only to BOP-filed motions, not to inmate-filed motions. More problematic for the inmates is threshold legal problem number 2, and that is the argument that DOJ has advanced that says that Congress did not make the change in 924C sentencing regime retroactive, and therefore it would be a an end run, a circumvention of that determination by Congress for a sentencing judge to reduce his sentence because Congress eliminated the regime. And there's a 4-3 split. I've got a couple of cases, a couple of cert petitions in the Supreme Court. There's a 4-3 split, and actually 3 of those 7 cases are Holloway Project cases. So that's still out there. There are 4 circuits in which there are limitations on what a judge can consider in a sentence reduction motion. But Holloway Project 2.0 was a litigation phase. Now, except no longer having to be hat in hand supplicants begging for mercy, only to get none of it, we were turned into the litigators that by nature we are. And first there's a very easy to satisfy exhaustion requirement in BOP, so you request a motion from the BOP, they never make it. And then you can make a motion directly with the court. And we made motions based on what we termed to be extraordinary and compelling reasons, absurdly long prison sentences. I've got one young man in eastern Pennsylvania serving 311 years for some bodega robberies where no one was hurt, less than $10,000 was stolen. We rely on the difference in the mandatory sentence today. There's an asterisk there because we can't rely on that in 4 of the circuits that have so held. And then we rely on the characteristics of our clients. Many of them were young men, legally adults, but now we know, based on social science advancements, neuroscience advancements, we know that cognitively you're not an adult when you're in your early 20s, so we rely on that factor. We rely on the fact that most of these folks receive their long sentences not because the prosecutors thought they needed to be taken off the street, but because they had the temerity to exercise their right to trial by jury. We rely on racial disparities, their maturation. Anybody who thinks someone who commits multiple violent crimes with a weapon and gets a 100-year sentence can't grow up into prison into commendable and even admirable human beings, just has no idea what people are capable of. And these are second looks. We present our clients as they are today to sentencing judges, and we found sentencing judges hungry to remedy these injustices. We've had 34 cases we've won at the district court level. All but 8 of those clients are out. The other 8 will be out soon. Their sentences were reduced, but not to time served. The average sentence reduction, 34 years. A total of 1,115 years shaved off their total prison times. 7 positive appellate outcomes. 26 clients released. They don't stop being your clients once they're released. We help them in that process. Many of our clients have been in prison 20, 25, one guy 30 years. So reentry is not a walk in the park when you've been in prison for that long. We now have 52 clients, all but 3 or 4, 2 or 3 are stacked 924Cs. We may enlarge the program to represent folks who are subjected to other harsh mandatory sentences. 25 active cases. I forgot to tell you. I can't tell you this story. We'll just have to have a beer someday and I'll tell it to you. One of our clients we lost, we snuck onto that 11th hour, 59th minute clemency list from President Trump. It's a story that implicates Mar-a-Lago, and it's a riot. But that's for another day. You're going to have to let me do the Arps lecture next year and you'll come back, I'll tell you that. 43 prospective clients. We have a pipeline. I'm so happy and proud to say that, I wrote a little piece in the Federal Sentencing Reporter about this, and I wrote in there, they've got nobody. There's no law school clinics. Well, I got a call 2 weeks ago from the dean of the University of Villanova Law School. He read that. He said, now there's a clinic. He got funding for it. So there's a law school clinic. Davis Polk has asked us if they could do some cases, so we've brought them in under our umbrella. They're doing cases. We've sent a few cases to the NACDL as well. Let me get to really why the whole point of this discussion. I hope it's a discussion. And it's why we gave up in our oral arguments, arguing this like elephant in the room, right? This undisputed, racially discriminatory invocation of the harshest sentencing provision we had. And it was remarkable to me. You know, we would brief it, and then in the arguments, you've got three examples here. One judge leaned over the bench, this was an appellate argument, and asked me if I had evidence that there was specific racial animus that I could point to on the part of the prosecutor who was arguing the case against me, who had nothing. Of course, bias is not always explicit, of course, but the case had been prosecuted decades earlier. Another judge expressed doubt that this should be a factor because at the time my client was prosecuted, the United States attorney was black. In one case, the prosecutor said that I was violating the disciplinary rules it was directly contrary to standards of professionalism set forth in those rules for me to raise the undisputed racially discriminatory deployment of 924C. And this pattern that you see reflected in these three little vignettes described here repeated itself. It devolved into whether I was accusing either the prosecutor in the courtroom with me or the prosecutor who decades earlier had brought the case was personally possessed of explicit racial animus. So we just stopped arguing it. We decided we're just going to save our guys and then talk about this problem somewhere else, hence talking about it here. And at the same time, race was always part of the equation. You could always see it, right? We, in one of our cases, the facts of the crime were never disputed. We were talking about 20 years later whether there ought to be a reduction, but we were confronting lines in briefs like this one. Most of the time, the robbers wore hooded jackets, and it's like, what? Why are we talking about that? Where's that coming from? Why are we have a prosecutor say that our client received no criminal history points, but his lack of a criminal record may be attributed in part to the fact that he enlisted in the Army. Like this young black man, of course, would have gotten some criminal history had he not. So race was like baked in, but it couldn't be discussed. So, you know, in a way, the title of this talk is misleading because I don't purport to have the path out. But this notion, and the last thing, here's the kicker. More than 30 judges agreed with us that a sentence reduction was appropriate. And they all wrote opinions. And not in a single one was there a mention of the Commission's data about this uneven, racially disparate use of 924C. Not in a single one. So look, I don't mean to sound like I was born yesterday. None of us wants to live in a system or be part of a system in which racial inequities are baked in, right? But we need to do something in a situation like this. And let me just suggest, and then I want to introduce you to Kevin for reasons I'll get to in a moment. You know, there needs to be data collection about charging policies and plea decisions. This data reported by the Commission, it's unusual. Like this is a identifiable category of cases, but there's insufficient attention paid to racial disparities in charging decisions, in plea offers. Congress ought to direct the Commission to not only collect that data, but to monitor it, inform Congress of racial disparities. I see no plausible defense or argument against a provision in the guidelines that allows for departures in cases, not mandatory departures. Obviously, sentencing is individualized, case-specific. But why shouldn't a sentencing judge be able to consider a sentence reduction in cases in which documented racial disparities are present? That's for folks who have yet to be sentenced. For our clients, why do we have these 4 adverse appellate decisions? Why shouldn't Congress explicitly authorize sentence reductions when racial disparities are revealed after the fact? DOJ has to establish, obviously, robust, permanent, implicit bias training. It started to do that in 2016, and then Donald Trump was elected and by executive order abolished it. But that obviously needs to be done. DOJ should welcome outside review of its actions. You know, some progressive district attorneys have invited institutions like the Vera Institute of Justice to come in, gather data about their charging decisions. It takes a courageous prosecutor to do that because the data might show, and they often have, implicit bias institutionally in the institutional decisions. And then, you know, lastly, we need to demonstrate to ourselves that we care about this. You know, this notion, not in a single case did any prosecutor dispute this kind of very troubling data, but no one evidenced, even in the slightest degree, that it ought to be cared about, ought to be at least talked about. You know, my colleague at NYU, Brian Stevenson, says if you really want to know a problem, you got to get proximate to it. You got to get down in the weeds. And I want you to get proximate tonight, which is why I invited Kevin to come. Kevin's a client. He committed 4 bank robberies in 1991 and 1992 in my old district, Eastern New York. 3 of them involved firearms. No one was hurt. He was indicted in 1993. He got a plea offer that would have resulted in a range of 7 years and 9 months to 8 years and 5 months, because it only involved a single 924C. But he made that mistake. You know, it's enshrined in the Sixth Amendment, but God forbid you exercise it. He exercised his right to trial by jury, and boom, Kevin got 46 years in prison. And then he served over almost 27 of them. He had a projected release date in 2034, but he was one of our early successes. He was released April 22nd, 2020, and he's rebuilt his life. It's not easy to be in prison 27 years and then get out, but he took a construction safety training course. He's OSHA certified. He took a program in paralegal studies, inspired by helping out his local pastor's efforts to feed the homeless. He started his own food pantry 10 months ago. He served over 1,000 folks in his Brooklyn neighborhood. He is very generous with his time. I always tell our clients, they owe us nothing. They owe the system nothing. The system owes them. They certainly owe us nothing. But some of them are aggressive in expressing their desire to help in any way they can, including by shining a light on this. And Kevin has generously donated so much time. He's spoken to my students. There's nothing better for students than to kind of see firsthand three-dimensional people who are at the receiving end of these unjust sentences, and that's Kevin. So I'm going to stop now, except I really do want to invite like a robust back and forth, and also invite, I don't want to put you on the spot. I didn't tell you I was going to do this, but invite you if you want to, before we have Q&A, if there's anything you'd like to say. I know you're not without strongly felt views about certain things, and if you want to express them, I should have not put you on the spot. But if you want to say
Put me
anything,
on the spot already. So, hello, how y'all doing? First and foremost, it is an honor, after doing almost 27 years in prison, to be here amongst you all. And
excuse me.
is this on? Oh, excuse me. Can y'all hear me?
Yep.
Like I said, it is an honor to be amongst you all, and I really appreciate it. After almost doing 30 years in prison, I'm here speaking at the bar for federal judges. But
Former federal judge.
well, you always be a judge, Gleason. Everything he has said is right on point. One thing I will tell you, well, my tenure being in prison, whatever it is, like this project, it should be merit-based. This isn't necessarily a scathing indictment against the prosecutor or the judge, because I did time in prison, and some guys just deserve to be there. I'm just being candid with it. So it should be merit-based. But in the regarding of this 924C, it's unfair. Congress didn't make it retroactive, but the onus of this should lie on the Supreme Court, because they said that they would revisit it on Dell versus United States, is when they made it lawful for you to receive this stacking provision. But subsequently, because they said that Congress didn't specifically state their intent of how it should be applied. So most recently, 2019, they did, and they said it had no business being applied like that. That was 19, it's 2022. They still haven't revisited that decision. Congress didn't make it retroactive, but Congress wasn't the one who dropped the ball. Actually, it was the Supreme Court that did, that they came up with this. So therefore, they need to fix this and make it retroactive. They need to fix this. If anyone have any questions, please feel free to ask me. I ain't gonna bite you.
I do.
Okay.
How do you wrap your head? Tell us about what it's like. You're on the receiving end of a 46-year sentence, 15% good time. It still means you've got 4 decades to serve. A number of our clients in that situation understandably behave very badly. Many of them think with legitimacy they're going to die in prison, so they behave badly. You didn't. Tell us how you wrap your head around that day by day? How do you do that kind of time? What do you tell yourself?
Listen, when I first came in, it was a bunch of us, young black men. You had your bank robbers, your armored car guys, you had your drug dealers, but everybody was receiving like life sentences, 160 years. And we used to joke about it, you know, 'cause none of us really believed we was going to do all that time. So we used to joke about it. Who are you going to see? The judge, all the judges was named MC Hammer, because we say, stop, hammer time, because, you know, you're going to get, till the, what they gave you? Till the sun burned out, 180 years. How much you going to get? And we laughing. We're not doing this time. We kids. We was all kids. But as them years begin to go on, like when you hit that 10th and that 15 years, you be like, wow, it's a long time. And like, I had kids when I left home. Now, them little kids that was in my arms is actually taller than me. I used to watch my mother bounce around in the visiting room hall when she used to come up and see me. And now she done went from bouncing around the visiting hall to now in a wheelchair. So, like, you be like, wow, I've been gone for a long time. And the reality really hit you. This isn't no joke. These people intend on having you in here for the rest of your life. So, it just wasn't, what sustained me though was I'm gonna tell all y'all women, especially the women, because some of y'all are parents, don't think your kids don't listen to y'all. Even if they do stupid stuff, don't think we don't listen. Because I had a good mother. I was raised right, all right? And certain things that I should have went overboard or everybody else was doing, my character, my conduct, that carried over with me, even in prison. And yes, I had uncles and cousins and older guys that went in and out of prison. But we had grooming. We was taught, regardless of what you did, you was taught respect. That's something that's not out here nowadays. There's certain things that, we wasn't animals. It was about the money. Now it's just indiscriminately, not justifying nobody's actions. But the lessons I learned from my house, I took them with me, and I thank my mom and my parents, my father, and everybody for that. So that's what prevented me, and my belief in God, and that's what prevented me from going over to the deep end. But the reality of it all, like I said, when a lot of us came in, it was a joke. We didn't, because we was like, who in the hell they think is going to do all this time? Ha, 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 ha. We just party. But in that 15, you start getting close to like 20, and then, you know, your people's, because like, I stayed into little things. So I was in the crack riots in Lewisburg in 1995. For those who don't know, it was a nationwide lockdown because they refused to change the crack law. So the jails went up. They shut the whole Bureau of Prison down. So they said I was instrumental in that, so they sent me to USP Terry Hut. So I stayed out there for 10 years. And then when I finally made it to a FCI, which is a medium Farrington, and then, see, my little daughter was under my arm, she's taller than me. My son's taller than me. My mother can't walk. I'm like, whoa. All a long time.
Yes.
Yeah. It's amazing. Well, first of all, although I found out a lot of it later, I had no business even being arrested. I was picked up with no indictment, with no detainer, no nothing. The prosecutor fictitiously said that there was a warrant, detainer, and everything for me. I later found out when Obama came into office, he started making them release the 3500, Freedom of Information Act material. So I was illegally detained all the way up until almost in my sentence. I was illegally being detained. They had no evidence. They had no nothing on me. The witness that they had a history of robbing banks and then saying that this guy did it, and they would work with him. So eventually they got tired of him. They wanted me to cooperate against him, but that's not my way. So I didn't cooperate and tell on him. So they said, well, look, if we're going to give you a 924C. And this is a true story. You got some transcripts too, Gleason. Says, we're going to give you a 924C. If you go to trial, we're going to give you 2 924Cs. I said, they can't do that. Because I'm thinking of, it's a Supreme Court case called Blackledge versus Perry, vindictive prosecution, right? So we standing up there before the Honorable Raymond J. Deary, and the prosecutor says, hey, he knew if he went to trial, I told him if he go to trial, I'm going to give him 2 extra 924Cs. I'm like, well, hold it. Isn't that vindictive prosecution? They're like, no, as long as they put you on notice, it's okay.
They superseded right before. The plea offer
Right.
expired shortly before the trial. The prosecutor went in the grand jury and superseded and
Right.
added 2 924Cs.
And then,
So why didn't you plead
when I
guilty?
was arraigned for him,
Why didn't you avoid the extra almost 50 years?
I knew I could beat him. I thought I could beat him, but I didn't know. But that was like it's the tricks, man. You know what's going on in that courtroom. Yo, listen. But now, He was like, he was indifferent. He was like, I got you. Come on, we can go to trial. My lawyer was really no help, and I paid for no help. It was it was like a few times Judge Deary got on him about how he was representing me and how poorly he was. Literally, Judge Deary Lee got on him about coming late and about how poorly he was representing me.
Well, that's water under the bridge, as they say. Any other questions for Kevin?
Yeah.
Yes.
First, thank you so much for being with us today. I appreciate it. How did you maintain your faith? Comes along, you're still silent. How did you know that this time? How'd you keep faith consistent?
Well,
I think that assumes a fact, not an evidence. Did you have faith in the system?
well, to tell you the truth, no. But look, it's like baseball. It was the only game in town. So I mean, it's the store. It's the only store in town. Commissary. So if you're going to get out, that's going to be the only way you're going to do it. What happened was there's a bunch of other guys just like me. We had started a 924C class, and what we began to do is write congressmen, senators, and stuff like that. When he did the Holloway thing, we just wrote him and told him thank you. We appreciate what he did. That was very big of him, and we sent him a Christmas card. And in that Christmas card, we sent a picture, and we all put our time on it, how much time we had. And when he left, he was going through his stuff and taking his stuff down, and he came across that picture. And he reached out to Holloway lawyer and told Harlan Protest and said, them guys in Louisiana, tell them send me 20 names, and I'll look into their case and see if I'll be able to assist them. And I was one of the 20 guys. And the rest is history, and I greatly appreciate it. I'm talking about it was a struggle. You know, it seemed like every motion you file, everything you do was being denied. But after Jeff Sessions became the Attorney General and he did away with all of the stuff that Obama and them had structured, Gleason told me, don't worry about nothing. We're going to be your lawyers until we get you out. And then 2019 came, the first step back. And the rest is history.
Yes.
Judge Gleeson, are you also working on the legislative front?
Yes. Yes. And, you know, there's a bill that made it out of committee that would make Section 403 of First Step, which reduced those sentences, restructured the sentencing regime, would make it retroactive. There's some other legislative prospects in the hopper, including a legislative fix of that adverse precedent in 4 circuits that says judges can't consider what Congress did. I find that so anomalous that in determining whether to reduce a sentence, a judge can't consider the fact that that Congress and that president decided that a sentence like that could never again be imposed. It seems a very odd thing to prohibit a judge from considering. But short answer to your question is yes. You know, it's a tough place in any stock in the legislature because nobody really saw First Step coming until it was almost enacted.
That also negates the separation of powers for them to say that.
Okay, we'll talk
Practice.
about separation of powers later. Yes. My relationships with them? Yeah. I honestly, you know, I really don't know. All I know is I'm an advocate, and I had clients, and I made arguments. I made them vigorously. They even more vigorously opposed them. I don't know. You know, it depends how personal it was to them. It wasn't personal for me. So I wish I had an answer to your question. I don't really know. Yes?
To what extent are the plea agreements in these 924C cases part of the record, or how did you make them so?
Well, everything's local, and in some districts, the plea agreements are formally entered on the record at the time of the plea. Sometimes they're not. Mild district judges are all over the lot on this, but we would be able to suss. One very difficult thing, by the way, is just getting the raw material for the motions for when someone's sentenced in 1994. Yeah. But we would get them. So you get a sentencing transcript, and you see that defense counsel said, "Gee, my guy was offered 7 years." You gather the information in any way you can, but there are information deficits all over the lot.
That's the only way that I've seen as a defense attorney to get a plea agreement into the record, so it might be considered at some later time. I wonder if you as a judge have other tips on how that might be helpful.
Well, after Padilla came along, there was different practices then to make sure there was no ineffective assistance lurking in the record. No, that's an imperfect part of our system. Although you go to someplace, Southern Florida, cooperation agreements are filed. And then there are different points along the spectrum of possibilities. But you're right, in some places, unless there's some fortuitous mention of it, it might not be there. We would talk to our clients. I've got one case that's pending where the client said it, but it's nowhere in the record. So I called defense counsel. So if I'm ever challenged in my assertion as an advocate that he was offered X amount, I know I've got not just my client's word, but defense counsel, who thankfully was there, who is still around 25 years later. But that's a problem. Yes.
How do your clients take on?
Well, it's merits-based, and, we were known in the Bureau of Prisons before we started the project. If these men had the right to vote, I could be elected to any office I want to get elected to after that Holloway thing. So I had the client base, and then, people send us their information. The key parameters, what have they done in BOP? Some people have 20 years of hits, disciplinary hits, that are bad. And judges will look at that. Have they, we've actually we've loosened our threshold requirements because we didn't want to lead with our chin at the outset and get an opinion that kind of blew the project out of the water. We picked our most sympathetic cases. And you got to read your judge like any other case. Some places where you're not going to make the motion. But people distinguish. The one thing I've taken away from this is a fuller appreciation of how we've lost sight of how human people are. They're so different. Our clients are different in many ways. They do things in prison to better themselves. There are offense conduct killers, somebody pistol whips a bank teller. It's not a case we're likely to take, even though you shouldn't spend life in prison for pistol whipping a bank teller. Those cases are backburnered at the very least. So there's offense conduct features. There are what they've done in prison features. There are, was it a trial penalty? How clearly can you demonstrate it was a trial penalty? It's different features of the case that we found have triggered judges' hunger to remedy injustices. Those are chief among them. I think we've overstayed our welcome.
Well, everybody is invited. We have a reception next door to honor Judge Gleason and Kevin, if you'll join us as well.
Yes, please.
And perhaps even answer some more questions or talking. That would be great.